Thanks, Michael. That's very helpful. I guess I will start by sort of maybe just clarifying what I'm agnostic on and what I'm not. I don't mean to be agnostic about whether the 14th Amendment is legitimate. I think it's absolutely legitimate, but I'm a non-originalist. I think it's legitimate because it is widely accepted by society today and because it is morally good, and I can't imagine our Constitution being legitimate without it, frankly. I have no problem with that. What I'm agnostic on is whether, if one is originalist and formalist about constitutional legitimacy, whether it was legitimate as an originalist formalist matter at the time, whether what happened did or did not technically comply with Article 5 as a matter of originalist constitutional interpretation. I think I mean that John Harrison's article is masterful. I think it's wonderful. And I think Akil has also done great work there. I think Bruce Ackerman continues to make a strong case that maybe they're seeing what they want to see a little bit in that. But I do mean to be agnostic on that question because I guess I want to push back against the idea that these are conflated, that if it technically and formally complies with Article 5, then that means that it has it is legitimate as a matter of popular sovereignty, that must mean that the people a supermajority of the people did in fact support the Constitution and did in fact ratify that amendment. I think there's plenty of room for saying that maybe technically something complied with the Constitution, but yet was not in fact endorsed by a supermajority of the people. One can certainly step back from the 14th Amendment and have these same kinds of arguments about the original Constitution giving the exclusion of the vast majority of the population from consideration from being allowed to participate in the ratification process. And here I just feel that even if it is true that one of John Harrison's theories works, I don't see how you can get from that to saying, well, that shows that in fact a supermajority of the American people did support the amendment and did in fact adopt the amendment voluntarily. I think they didn't support the amendment and they didn't adopt the amendment voluntarily. And whether technically we can cram that into the terms of Article 5, I'm not sure really affects that question. I mean, I think that if one imagined tomorrow the Obama administration proposes a constitutional amendment on, mandating a welfare state as a constitutional matter, imagine that the Democrats win the next congressional elections and actually hold both houses, and that gets it through Congress, and then the administration just brings the army up to a bunch of recalcitrant states and says, here's a nuclear weapon, we're going to detonate it in St. Louis if you don't ratify, and the legislature of Missouri holds an emergency meeting to ratify, I suppose technically John Harrison would say that complies with Article 5 because we're not supposed to look behind the magic box. The bottom line is there's a written resolution from the state legislature saying we ratified it, and the Congress has accepted it, Secretary of State has accepted it, end of story. But I think if I were trying to ask the question, is that a democratically legitimate amendment? Does it reflect the views of the supermajority of the people? I think I would have to say absolutely not. And I think what we have here is a lot closer to that than it is to the rosy picture that is sometimes painted of constitution making in America by some people who are in the originalist camp. So I'll leave it at that and take questions.
We have a great deal of wisdom in the room, at least if a supermajority is a measure, since we have a supermajority on the queue. With the with the sense of legal niceties that was shown during the ratification of the 14th Amendment, I will put myself at the end of the second triad, and we'll start with Earl, then Larry Alexander, then Larry Solon.
Okay, I want to start with a couple of things that I can't let pass that I guess I think you can decide are either small points or large points. First, the Constitution is not a compact among the people of the United States. It's a compact among the states. It's absolutely clear from the beginning, and I could defend that. Second, judicial review is not just about overruling the terms of democracy. Rather, it is largely about disturbing decisions of the states generally, whether by the Democratic branches or the popularly elected branches, or by courts through state constitutions or whatever. But that's not I just couldn't let those things pass, but those aren't at the core of the paper. Well, in a certain sense, about the democratic part, it is at the core of the paper. But beyond that, I think that the main problem that I have with the argument is that it makes, it conflates two, and I guess it's part of arguments that some originalists make, that it conflates two quite different questions. The first question is why we might consider lawmaking, any kind of lawmaking, legitimate. And the second question, that's different from the question of once we assume that the lawmaking is legitimate, that is binding, how should we interpret that law however it was made? Now, with respect to the question about how we determine whether it's legitimate, if the 14th Amendment is not legitimately part of the Constitution, it's not legitimately part of the Constitution. It doesn't matter how you interpret it, it's over, right? It's just not something we enforce. If it is something that we want to enforce, I don't think it makes a difference about whether it was democratically created or not. And here, I want to make a quick analogy to the pre-1965 version of state legislatures, which were grotesquely malapportioned, but nobody questioned, it didn't change the interpretive mode when they became democratically, after the one person, one vote. That is, it didn't matter. So why then are we, what's my justification for originalism, and therefore the right one? That really, I think the basic justification for originalism goes back to sort of the question of whoever makes the constitutional provision, which is legitimate, however it's done, how are they expected to make the decision about whether to vote for it or to whether to impose it or whatever? The only thing that the only way they can make that decision is based upon the knowledge that they have at the time. And originalism, otherwise, that the creation of constitutional amendments and constitutions generally simply becomes a random exercise. That vote on this not knowing how it's going to change in the future at all. So it seems to me that originalism is the only way, some version of originalism is the only way that allows people, whoever is making constitutional provisions, to make any judgment about whether those constitutional provisions are a good idea or not. And that's independently of the question of whether they are in fact a good idea, or whether we think, or the arguments about the fact that there is a 2/3 supermajority mean they probably are a good idea. If they have the legitimate authority to make them, they have to have some basis on which to make a decision about the language, and only some version of originalism gives them that idea, so therefore we should read it back into the constitution-making process.
Larry Alexander.
Yeah, my remarks pick up on Earl's to some extent, and on the last the last part of Michael's remarks. So I always make the distinction between what something means and what its authority is. We have plenty of documents where we can discuss what its meaning is, like the Constitution of the Confederate States of America. No one thinks they have any authority over us, but they have a meaning, and it's the meaning. It's the semantic meaning intended by the people who wrote it. And so I'm one of those originalists you identify on pages 51 and 52. This is an interpretive theory, right? It's about what words mean. So on the question of its authority, you said, and I think this is right. Well, the 14th Amendment is authoritative for us because we accept it today. We accept it, and I actually think the entire Constitution that's where its authority rests. It's because we accept it today. But then the question is, what's the it there? There's a referent, right? And you use that in several places, and so now if it isn't the original semantic meaning of the 14th Amendment, then you have a bunch of marks in between the 13th and the 15th. And what are you doing when you say we accept it? You mean we accept the marks? What do we accept there? It seems to me that what we accept is the original meaning of those marks. Otherwise, it's just marks. Larry Solon.
So rather than pile on, let me suggest that one way of characterizing the remarks made so far is that interpretation is one thing, or the fixation thesis is one thing, and construction or the constraint principle is another. The part of originalism that affirms the fixation thesis isn't touched by your argument. The part that is engaged by your argument is the constraint principle, right? Now, it seems to me that there are a multiplicity of justifications for the constraint principle, for the idea that we would be consider ourselves bound by the communicative content of the text. I think maybe Randy will say something about non-popular sovereignty reasons. I just want to play Colby's advocate without characterizing Colby as the devil, and suggest that if you want to argue your positive position, the position that you advance towards the end of your remarks, you're going to need a theory of construction. That is, you're going to need a constraint principle that makes something else other than the communicative content of the text binding. This is a variation of the it takes a theory to beat a theory position. Only here, it takes a position to beat a position, right? You have to have something that you're arguing for. So what is it that your theory justifies as constraining? And, I think you're going to end up with some version of Brennan's argument about contemporary ratification, right? And what Larry is going to say to you is that contemporary ratification has to ratify the communicative content of the text. And you're going to have an answer for that particular argument, right? And you have to have an affirmative position. It's not enough here to poke holes, because Larry's move, right? Larry's move actually admits your argument, but gets the originalist version of the constraint principle. Without a competing position, you don't have an argument.
Tom, then Michael.
Okay, thank you for all that. Thank you for not technically labeling me as the devil. I appreciate that. So I guess I'll start with Earl saying I'm conflating here why is the Constitution legitimate, and if it's legitimate, how should we interpret it. I guess maybe I'd like to leave that to Michael. I feel like I believe Michael to have said that one needs to conflate those things, and that one should not separate those out as two separate inquiries. As to Larry, what is the it that we are bound by if we take the legitimacy of the 14th Amendment to be the fact that we accept it today, which I guess goes a little bit to Larry S.'s point. Also, I don't mean to articulate at page 50 something of the paper a grand non-originalist theory of constitutional interpretation, but I guess I feel comfortable saying that the it that we are collectively bound by when we give the 14th Amendment legitimacy because we accept it as a society today is the 14th Amendment of incorporation. It's the 14th Amendment of Brown and Loving and Lawrence and Roe versus Wade, and everything else that the 14th Amendment has been interpreted to mean today, that the American people have accepted it to mean, or at least that it has been interpreted by the court to mean in a world in which we generally accept it as a people. I'm not sure that it takes a theory to beat a theory. Yes, I suppose it does, but I think sometimes one can suggest that another theory has problems, or another theory doesn't apply in particular circumstances as effectively as one might otherwise think it does, and accomplish something without necessarily going on to articulate a fully thought out and defensible alternative theory. On the point of are there other normative reasons to be bound by the original meaning of the Constitution that are not dependent on the sort of popular sovereignty or supermajoritarian consent rationales that I try to undermine with this paper, I guess I'd like to hear more about them because to the extent that they're there, I don't think this paper undermines them. I think this paper seeks to undermine some particular defenses that are the most commonly articulated ones. If there are other defenses that are not touched by this that are powerful, then I have not touched them with what I've done.
Michael, you want to say a word about that?
I suppose. One of the things I liked about the paper is I do think it makes me at least think about whether originalism is an interpretive theory or whether it is grounded in the principles of the U.S. Constitution and essentially the idea that the people have an original right to establish for the republic the principles under which they're going to be governed. I'm a little tempted to say it's like certs. It's a breath mint and a candy mint, which is really but that would be a dodge. Obviously originalism can work for any type of regime, and so if you have the Emperor Napoleon lays down a code, you can use originalist interpretation to understand what Napoleon's code is, and it has nothing to do with popular sovereignty or anything else. Originalism is simply a means of making sure that whoever it was who had power to enact a law, that what is being done is what was meant. But I think when Tom talks about normative defenses of originalism, he's asking a slightly different question. He's asking why one would be attracted to a system like this, and I do think that we might not be. We might be attracted to the Napoleonic system on some ground, like Napoleon's code was really good, in which case. We might be originalists, although I'd be inclined to think that ameliorative originalists would be even better, since I doubt that Napoleon's code is perfect. It does seem that a popular sovereignty basis is a closer fit with the normativity of originalism than anything else. And so in that sense, but again, it does seem to me that it all depends then upon what is the republic in 1868, and if the republic certainly, if you take the southern states are out of relations with the Union theory, I see absolutely nothing wrong with saying that there was popular sovereignty, there was deliberation, there was supermajority, and there's really not a problem at all.
Our next triad is Randy Barnett, Chris Green, and myself. Randy?
First of all, I want to echo everything Mike said positively about the paper. I really did enjoy it, and I liked it, and I thought it was really quite fair treatment of the position with which you disagree. And it took a lot of work to write it. I have one objection which is easily fixed, and I predict you will fix it. And then I have another objection which I predict you probably won't change the paper to reflect. But the easy one is that it goes back to what Larry said. There are non-popular sovereignty defenses of constitutional legitimacy that are then used to as the first step towards defending originalism. And the one that comes to mind is the one I advance in my book. You cite my book several times, and you cite it completely accurately and appropriately. So I have no complaints about how I'm treated in the paper in an affirmative way. But there is a glaring omission, and that is that I distinguish in the book between the issue of constitutional legitimacy and the issue of constitutional interpretation. And I think these are two separate issues. I think your paper forces originalists who haven't dealt with that distinction to think about it more. But this was dealt with, and there's an express repudiation in my book of popular sovereignty. There's one which is the part that I hated to publish because it made the book less popular and less in sync with other people who would be receptive to the other arguments of the book. I mean, David Santel, when he gave a comment on the book, said, "I love this book after page 79. I just wish that first part hadn't been there." And I knew that would be the reaction, but I felt it was necessary because that was my position. And so it's an anti-popular sovereignty, defense of constitutional legitimacy, and then there's another defense of originalism I think follows from that. I think this just needs to be acknowledged. It doesn't have to be, you don't have to make a big deal about it. You're right, that's not your target. But you've got to acknowledge that this position exists and it's been, out there for a while. So anyway, that would be the easily fixed part of the paper. The part that's harder is, partly I don't want to just repeat what other people have said. Your target really is the theory of constitutional legitimacy held by many originalists. It isn't necessarily originalism. So you're really, there's people who are not originalists who hold that same view of constitutional legitimacy, but they're not originalists. And so I think you ought to, so in that sense you're kind of wide of the mark, but that sort of goes to what other people have said. And I guess I would just add to that, that there's a distinction here that doesn't really come through the paper. It might be necessary for you to clarify it, and maybe this will help you sort out your thinking, and that is there's a difference between the rule of recognition that by which we identify what the positive law is and whether the positive law, this gets to Larry's law versus authority, and whether the positive law has whatever quality it must have in order to be binding in conscience on the people, and anybody, whoever the relevant audience for that law is. Those are two separate questions. And you raise a challenge, kind of your story, which is, I agree, an accurate story, raises the challenge of, well, how did the 14th Amendment actually become positive law? I mean, that in some ways, that's sort of Ackerman's theory question too. But I think under your own theory, under your own belief, it was positive law. I mean, I don't think you're going to want to say at the end of the day that it only became positive law in the 1960s or at some other point. I think you're going to want to say it was positive law on day one. And because it passed some rule of recognition, you're going to have to say what that rule of recognition was. You have the same problem everybody else has, therefore, with respect to this issue. You don't get out from under this. But whatever it was that makes it positive law, we then ask the second question: what did it mean? Oh no, that's another question. Is it good enough to be binding? And I think one answer to that's the popular sovereignty argument. You've created a problem for that, but on the other hand, you've seen some pushback from that direction. You're not going to get that from me. The other answer is the argument that it established a system of lawmaking that is sufficiently good enough to ensure that the coercive rules that are going to be imposed on the people do not violate the rights that they retained. And that was true from day one of this text, if it's a good enough text. So that's the alternate. That's the alternate view. So I think that's something that I suspect you're probably not going to change too much. Because you really aren't attacking originalism, but I do think that you have to distinguish between the rule of recognition, how something becomes positive law, what makes it legitimate, and then what does it mean. There's at least three questions there that gets kind of smushed together as you take aim at originalists.
Chris?
So I wanted to say a little bit in defense of loyal denominatorism and say it strikes me that this argument is basically a restatement of the dead hand objection. This was adopted by 3/4 of the loyal states. If you think it became law in the North on February 12th, 1867, and then the southern states agreed to it. Okay, then the objection is a little bit like saying, well, the original Constitution, it was only ratified by 13 of the 50 states. That's not a supermajority. And the answer is, but all the other ones agreed to it when they wanted to get back in. So it seems like you've got a kind of loyal North to former Confederate South. Loyal North is to the former Confederate South as Generation 1 is to Generation 2 analogy. And if you see the 14th Amendment as authored by, not the entire country, but by the loyal North, then that actually gives you a very strong argument, I think, for originalism, because you should see it as authored by Generation 1, not as this joint project. In fact, that fits with the moral tradition of oath interpretation of preferring animus imponentis over animus jurantis. Not that I know how to pronounce Latin. But the no mental reservation tradition, that when you take an oath, you're not swearing to support the thing that you have going on in your head, you're swearing to support the meaning of the text as it's interpreted by the person imposing the oath, i.e. the meaning of the text in light of Northern principles, i.e. the meaning of the text in light of Generation 1 principles.
My question follows up on Chris's, which is this notion of a loyal denominator. And I want to ask why there need be any hypocrisy in Northern insistence that we fought the war to keep the South in the denominator, but there is a notion that people can't profit from their own wrongdoing, something Dworkin talked about the case of Riggs against Palmer, that if you murder your father, you can't claim, even though the text of the will says that you win. In evidence law, if you shoot the witness dead, you can't object on hearsay grounds that the testimony against you is not live testimony. And so is there not a principle of estoppel or moral standing here that would say that the South, having waged war for the sake of treason, even though it had lost the contest and was still in the denominator, was itself estopped from asserting its rights?
Okay, again, thank you for another powerful round of thoughts. I guess I'll start with Randy. Yeah, I'm sorry. This is all very helpful to me. The target of this paper is not originalism. It is a theory of popular sovereignty that many originalists hold as the normative basis for their choice to be originalists and their claim on the rest of us that we need to be originalists too. I try to be pretty explicit in the paper that for those originalists who don't rely on normative defenses at all, whose originalism is more based on semantic theory, I don't think that you're bothered by this paper. And I think where I make a mistake is in not only suggesting, but I think at some point actually saying there are no other normative defenses of originalism besides those that ultimately collapse into popular sovereignty. And that is a change I will make. And I think it's an easy one. It's a chicken shit one, but it's an easy one just to sort of say there may be other ones out there. I don't have any beef with you, at least not in this paper, and because I don't mean to. I'm trying to take to target one particular theory, but then say, look, this normative basis is actually at the core of at least many popular conceptions of originalism. So I think it has implications for many versions of originalism in many people's minds, but I'm not trying to overstate what I'm doing here. I guess I should talk about the loyal denominator theory because it's come up now 3 times. I started to write a section on that as one of the possible arguments on the other side. And I took it out, and I think I foolishly took it out because I thought it wasn't going anywhere and no one would make it, and I didn't want to erect a straw man because I guess I'm kind of an idiot because it turns out that obviously it has a lot of draw to a lot of people. So here's, I think, what I was going to say about the notion that one can get around this problem by saying that in order to establish the necessary basis of popular sovereignty, one needs simply get a supermajority of the loyal states, which the 14th Amendment did with no trouble whatsoever. I took it out, I think, because I wanted to, and I still want to rely on this notion that there's a difference between whether the 14th Amendment was technically, as a formalist matter, consistent with Article 5, and whether the 14th Amendment does indeed represent a consensus view of a supermajority of the American people. And I thought that this went only to the former rather than the latter. And I guess there's still a lot of sense that I can't divide those things. And if I can't split those things out, then I really need to put this back in. I think part of why I don't think that argument flies all that well, especially if one is trying to think of this in terms of, does it show that a supermajority of the American people did consensually agree to this amendment? First of all, the 13th Amendment was ratified by all of the states, and it was sent to all the states for ratification, and there was no thought that one could get away with simply having it ratified by the loyal states. Second, and Don sort of got at this, the whole northern theory of the Civil War was that the South did not secede and cannot secede, and that they were at all times part of the Union. And we were willing to fight a war in which 700,000 people lost their lives to establish that principle. So I think it's a little bit difficult to then come back and say, oh yeah, but they seceded, so they weren't part of the Union, so we didn't really need them to ratify. I think there is a bit of a hypocrisy there. I like Don's suggestion that maybe there's a kind of an estoppel argument that one could make there, and I need to think about that. And then finally, I think Michael mentioned in his remarks that Bingham was one of these people who said that, well, the denominator should really only include the loyalist states. I think a number of the radical Republicans said that, and then they backed off of it. And I think at the end of the day, this was not even the theory at the time of the Republicans who held all the cards. Even they didn't want to come out and say, oh, well, don't even have to include the South in the denominator. It didn't even fly on its own terms back then. They all backed away from it. I think maybe they only backed away because they realized that they could do it with the bayonet, and they didn't need to. They could eliminate any fear or doubt that would be raised by relying on that theory. But I think it does indicate that even at the time, this was not the way in which we conceived of the ratification of the 14th Amendment. And like I say, if at the end of the day I still want to push this notion that one can comply technically with the language of Article 5 without actually manifesting a supermajority assent of the American people. And I think that would be what would happen. Like, these were part of the American people. These are the people who are bound by the 14th Amendment going forward. And they quite clearly did not want to ratify it and ratified it involuntarily. And I don't think you can get away from that by saying, yeah, but they were, they brought it on themselves. I suppose they did. I'm sure they did. But be that as it may, they didn't support it. A supermajority of the American people didn't support it.
Chris, I see you want to get in, but I'm going to move you to the back of the line. We've got a long queue here, and for Tom, it doesn't get any easier. It's David Upham, Mike Rappaport, and Will Bowd.
Okay, just a couple points, slightly different from Earl Maltz. I'm surprised that the supermajority theory is so prevalent, because it strikes me as a misconception of Article 5. I think Article 5 is majority of states that is large enough to represent a majority of the people, but I won't elaborate that. So it's both partly federal, partly national majorities. The thing that bothered me most about your paper was what amount to, and I'm not sure I'm using the term correctly, begging the question, when you keep on talking about the South was against and the Southern people, and you insist that they are part of the people. If the Republicans were right and free blacks were already citizens, then they have to be included. And you mentioned that you saved that discussion to the end, to a refutation, about, well, when we speak of these states, why don't we speak of the free blacks who were in the South? And I think you understate the evidence that's in favor of legitimate popular ratification in the South. You say there's at least only maybe three states in which blacks had a majority. But there were three others where there were 45% of the population or more. You take those, and that's the 6 states. You mentioned you need 6 states in the South to ratify. And those states were states like Alabama, for instance, which arguably had a legitimate, as Michael McConnell said, a very pro-Republican government elected. So this, to a certain extent, it all depends not just on the Republican theory of the Union, but also on the Republican theory of citizenship. If the citizenship clause is declaratory, then the 14th Amendment, assuming that free blacks want to ratify the 14th Amendment, and all the evidence of their political affiliations during Reconstruction indicates that they were enthusiastic about the 14th and 15th Amendments, then you have, it seemed to me that you should include some discussion of that at the beginning, rather than simply assuming the word South and Southern people includes only whites. Further, you speak about the bayonet, and it seemed to me that it's not so much offer you can't refuse type bayonet. It's more of a type of thing where I'm thinking of a very progressive decision, Stewart Machine Company, where they said inducement and duress are not the same thing. And I wonder to what extent this is closer to inducement as opposed to force. And especially if it is one of these real tough deals, a tough bargain, then it makes it all the more important that you be faithful to the original terms. You don't say, all right, you're gonna have to swallow this medicine, but we'll let you back into the union. We've been doing some thinking. We decided to change the terms all along. Fourth, I think you understate the degree to which this partisan measure, the degree to which the Republican Party was in fact the supermajority in 1866. Because the results of the 1866 election, which was run on this, gave them the numbers you said they had to have to ratify it beforehand. And to say they won so many seats in the northern states in the 1866 election, they may very well by that election have had, even if the South had been included, had the 2/3. I'm not sure about this, but I checked that initially. It looked like they actually did win enough seats to get the numbers you said they needed.
I think they won a supermajority excluding the South, but not including the South, but others are
Okay.
close to that.
And there's only 25 states in the North, so it's not a 36. But
Maybe I was thinking the House of Representatives, in terms of it, not the Senate. And lastly, if you take the Republican states that gave a majority to Lincoln in 1860, and you add those 6 states where blacks were 45% or more, you've got at least 65% of the American people in those states. That's like a party. It's more like what somebody said after the 1964 election. We have a party and a half in America. And lastly, you were mentioning the date, widespread acceptance. And I was wondering what your date for that acceptance was. Because it seems to me if it in fact is 1965, then maybe that is the originalist date that originalists have to accept. But maybe the date is as early as simply the ratification of the 15th Amendment. If you accept that was a valid one under Article 5. Because the 15th Amendment, by its name and by some of its terms, seems to incorporate the 14th by reference. Or just maybe the 1872 election, because the Democratic Party's platform said, we refuse to reopen the questions that have been settled by the 13th, 14th, and 15th Amendments. And if that's the date, then the challenge you make to originalism strikes me as not, it make a big difference if 1872 is different from 1866. But it's not a Warren Court issue.
Mike?
Okay, well, I too think this is a good paper for a lot of reasons people have said, even though it criticizes our theory. I don't think it was a mistake to discuss the supermajority theory, in contrast to David. I guess I want to sort of come back. Some of what I'm going to say is like sort of what other people have said, but it's sort of just in the context of John and I theory. So the first thing I want to say, just to clarify, ours is not a popular sovereignty theory. Our theory is that the Constitution is a desirable Constitution, and one of the reasons why we can figure out it's a desirable Constitution is enacted through a desirable supermajoritarian mechanism. So it's not a popular sovereignty theory. It works a little bit differently. And so it's all about there being a desirable process for enacting things. And that process, one of the key features of it is consensus, but that's not the only desirable feature of it. There's other values, and those are going to come into sway here. It's very complicated when looking at the 14th Amendment. We go over its enactment and the various theories. We've gone over some, not all the different theories. So I'm just going to assume for a second Akil Lamar's theory and draw out the implications under that view, but you can do this under a number of different views of it. So Akil says it's okay to exclude the southern states because they don't have Republican forms of government. Right? So let's say Akil is right, then it's legal. But is it enacted in accordance with a desirable process? And I think that it may have been. So the first thing to say, and this is just only I don't know how, it's not the main point, which is that if the southern states were actually excluded under this theory, that means, on the theory that they didn't have a Republican form of government, then a supermajority of the people from 1787, including the southern states, would have signed on to this, right? In the sense that they said you have to have a Republican form of government. And that actually suggests that excluding anti-Republican states may have something good about it. Now, why would that be? Why would you have this requirement of Republican states? And I think the view that the Constitution takes, actually, about these things is that this is a sort of precondition for being part of the Union, for us sort of sharing our sovereignty, if you will, or our governance with you. They seem to be saying that, look, we think that monarchies and other non-Republican states lead to bad results. They don't just lead to bad results for the people in their states, although they certainly do. They also lead to bad results in the national legislature where they're going to participate. They lead to bad results through the constitutional amendment process, right? And so, so really in the end, you have this trade-off. On the one hand, you have consensus, right? That's a really important value. We build it in. On the other hand, the original Constitution builds in the precondition of having a Republican form of government. And then you sort of have this trade-off. And under the Republican form of government argument, it's a more desirable process. The way the trade-off is worked out is to say that the exclusion of non-Republican states outweighs the consensus. Because we just don't like the way non-Republicans behave. Now, I think that's a reasonable argument. And it's all about there being a desirable process, not so much popular sovereignty and the like. So that's just one version of it. I could go on with all the different versions of it. I guess the last thing that I want to mention is on these loyal denominator theories, a lot of the reason why they didn't just pursue that is they were concerned that the southern states would then come back and say these constitutional amendments were not validly enacted. So they were doing it both ways. And you actually see that. You see Akil quotes a bunch of people saying exactly that thing. So it's not that they reject that mechanism. They want to be extra careful in enacting it.
Well, since in the last triad, several people spoke up for the loyal denominator theory, I feel like I should speak up for the coerced numerator theory. It seems to me that popular sovereignty under the gun is still popular sovereignty. And you kind of repeatedly ask questions like, well, does this really reflect what a supermajority of people wanted? And I guess the question always is, well, wanted relative to what? Because almost nobody who votes on our rights or chooses a constitution has it say exactly what they would love it to say in an ideal world. There are a whole bunch of factors ranging from politics to practicality to external threat that force people to write the constitutions they write. So the original Constitution contains a bunch of stuff, in part because people didn't want to get carved up by the European powers, and so they were willing to agree to stuff about slavery that they didn't want in either direction. We don't see that as a violation of popular sovereignty. We see popular sovereignty as the right to make choices from whatever choice set you're given. And similarly, that's true of Rhode Island and everybody else who kind of signs on because it's better than the alternatives. And I guess the so-called coerced ratifications here just strike me as the same problem, maybe to a different degree, but certainly not different in kind. So I guess this shapes into, they had a choice whether to take the deal, and they chose to take the deal, and that seems like it's just as much of a choice as every other choice constitution makers have.
Okay, I'll start with that, because I think David often made sort of a similar point of saying this is more inducement than duress. You're right. I guess it's more a difference in kind or difference in degree than a difference in kind, and that every time one seeks to ratify an amendment, you had to sort of take the Bill of Rights as a whole or not at all. You had to take the whole original Constitution as a whole and not a whole, and everybody gave something up in the compromises that is constitutional decision making. And the question is whether you voluntarily agree to the choice that you've got, not whether this is the choice you would have picked had you been able to draft the thing. I think that at some point one goes far enough along the scale that one can no longer say that this reflects popular sovereignty. Again, if I say to you, let's go to dinner. You can pick between these two restaurants, and you think, I don't really like either ones, but I guess I like this one better than that one. You've agreed to go to dinner, and that's where we're going, and hey, I'm paying. If I walk up to you and literally put a gun to your head and say, you got two choices. I'm going to pull this trigger, and that will be the end of Will Bode, or we're going to go to this seafood restaurant. we're going to the seafood restaurant, even though you don't like fish. And I don't think that that was a voluntary choice on your part. I don't think that was, I think that's duress, not inducement. And I don't think that one should say that, hey, look, between the choices you chose, you were given choices, you made a choice, and we should view that as your free will in a way that makes us feel comfortable saying that you're bound by it in the future. So again, I think we can disagree about where we are on the line, and I suppose that's part of what the disagreement is. I think we're pretty far down the line in the minds of the Southern whites. Just a couple of things. David, you make a good point that there are some pretty high African-American populations in some of the southern states, although not technically a majority. I still think, based on all the history that I spent a lot of time reading, that, if there had not been a process that so effectively discouraged many Southern whites from participating in the election of the legislatures that went on to ratify the 14th Amendment, that even in those states, I mean, you literally, in 1867, you don't find virtually any white Southerner on record as saying they support the 14th Amendment. You find a few of them who are, Union loyalists saying, well, it's the best we can do, even though I don't like it. It's just truly universal. Or really, really close to it. And so I think if you're at 45%, you're not going to get to 50% without some form of northern, aggressive northern coercion. Maybe I should come back and say, I'm maybe not being fair in dodging this question. What is the date at which, on my theory, the 14th Amendment becomes effective law? I don't have a great answer to that. I guess my sense is, it was effective the day that Congress treated it as ratified, but there was no good reason to give it an originalist interpretation from that day or not going forward. And it is now not only effective, but legitimate, because we have collectively assented to it in a way that maybe the people didn't in, say, 1875. But the way in which it is legitimate especially counsels against mandating that we give it an originalist interpretation, in my mind. For Mike Rappaport, thank you. That's helpful clarification of your theory and John's, that maybe it's not just supermajoritarianism that makes the Constitution desirable from a functional standpoint. There are other ways in which there are other reasons why we think it will produce good results. And the Republican form, the fact that it was produced by states that have a Republican form of government is another reason why we think it produces normatively desirable results. And that's a reason why we shouldn't worry that the non-Republican southern states were forced to go along, because who cares? They had we let them participate without coercing them, they wouldn't have given us desirable results. I guess I would just say that, like I say in the paper, I think there's a danger that sort of argument proves too much, because the original Constitution was not ratified by a genuine supermajority of the people that would be a Republican form of government, on Akil's own theory that if you disenfranchise a significant portion of the adult male population, that makes you not a Republican form of government. Then, well, the free adult male, that's convenient, but by today's standards, I don't think the original Constitution was adopted by states that have a government that we would think of as Republican today, insofar as only white males and a few free black males and wealthy people were allowed to participate. So I worry that if we start saying, in order for the Constitution to be normatively desirable, it must be the case that its provisions were enacted through a legitimate Republican form of government, that we may end up, undermining the Constitution as a whole. Okay, so I think that's what I have to say.
Michael, you have a word?
Just two quick points. One, as Harrison points out, the classic distinction between inducement and duress is whether the alternative that you're presenting is legal or not. And so the reason why, pointing the gun at the head and saying, go to the fish restaurant or I'll shoot you as duress is because I don't have a right to shoot you. I do think that Congress had the right to occupy insurrectionary states and to govern them until such time as they were ready to be back in the Union. And if that was lawful, then it was not really duress in any legal sense. More importantly, I'm really puzzled by and I think troubled by the idea that what has been popularly ratified is what we've got now. You tick off the cases. Does that mean it seems to me that kind of interpretation it goes against both the fixation and the constraint principle. Do you think that the court does not have the authority to depart from anything? So the law as of 2013 is now been fixed, and so we can't change from that. So we can't move ahead in any way. That seems very odd to me, and particularly then if popular ratification in fact took place at some time in the past. Was it fixed as of the day that it was popularly ratified and then legitimate? I don't know what the content is, and I think it's just a constitution that has no meaning at all and no constraining meaning. It's just whatever we happen to be right now is good. It's sort of like we live in the best of all possible worlds.
There's a governor of California who said that he hated nominating judges because that way you make 9 enemies and 1 ingrate. The same can be said of extending the queue. You would make a few ingrates and a lot of enemies if you singled anyone out. I take comfort from the notion that in closing this panel, we are not closing the conversation. And I hope you all join me in thanking Tom for most.
Can I just make one final? Am I not allowed to make that final point?
Let the ingrate speak.
I just want to say, I think what is popularly ratified is law now is the 14th Amendment that we understand to have an evolving content and respect contemporary values and to be capable of evolving to respect the values of society as a whole. So I think that's the 14th Amendment that is popularly supported, the one that can support Brown and other evolving interpretations over time. I don't think it's any one of those particular interpretations. All right.